Everyone tells me I need to get a power of attorney, but I don't know what that is. What do I need to know?
It's important to plan ahead for the future and consider what will happen if you become unable to manage your own financial affairs due to some health problem or age-related incapacity. Who will manage your bank account, pay bills, arrange for services if you can't do it yourself? Many people use a power of attorney document as a tool to help plan for the management of their financial and personal affairs in case something happens to them. A power of attorney document names someone else to act on your behalf if you become incapacitated. That person is called your attorney in fact. Unfortunately, even with a legal document such as a power of attorney, people can get into trouble. An incapacitated person can become the victim of financial exploitation at the hands of their attorney in fact. Every year, people turn over their right to manage their financial affairs through power of attorney documents, and every year we see people not following the rules and violating that relationship of trust, often because they or their attorney in fact don't know the rules. Before you sign a power of attorney document and name an attorney in fact to act on your behalf, you should know the rules in order to protect yourself. This video will give you some tips to help you avoid becoming a victim.
Is there anyone who can help me? Who should I talk to?
Ideally, you should discuss financial arrangements and estate planning with an independent professional well before you actually need those plans. Advanced planning with help and advice from an independent professional, such as a lawyer, is a good first step. A lawyer can suggest and explain a number of different financial planning tools, including a power of attorney, a living trust, an appointment of a health care representative, and other property arrangements such as joint ownership. Lawyers often recommend and prepare a power of attorney document to help you plan for the future in the event you become incapacitated. A power of attorney is a legal document that allows you to name someone to act on your behalf in the event you become incapacitated and unable to manage your own financial affairs. In this document, you are referred to as the principal. The person acting on your behalf is called your attorney in fact. Even though this person is called an attorney in fact, this person doesn't have to be a lawyer and usually is not. This person is just someone whom you trust. To be valid, a power of attorney document must be in writing. It must name a specific person as attorney in fact. It must give the attorney in fact the power to act on behalf of the principal, and it must be signed by the principal in the presence of a notary public.
Who should I appoint as my attorney in fact?
Only appoint someone you trust to act as your attorney in fact. The trusted person may be a family member or a friend, but it is best if that person is financially independent. Never appoint someone to be your attorney in fact unless you trust that person completely. Your attorney in fact should also be someone you know very well. It's best if the person you appoint has their own independent source of income. Avoid appointing someone who has been in trouble with the law or who has financial problems. There is no government agency that regulates the actions of your attorney in fact. The only watchdog to protect your interests is you. Some people appoint two attorneys in fact, with the idea that the two can watch over each other's actions. You may also want to consider appointing two attorneys in fact, so that they can supervise each other.
If I give someone my power of attorney, is it still my money, or can it be taken?
When you sign a power of attorney document, your money still belongs to you, even though you've appointed an attorney in fact to handle it for you. Your attorney in fact must protect your interests and use your income and assets only for your benefit. That means the attorney in fact cannot use your assets for their own benefit. It's your money, not theirs. It has to be used for you.
My mother gave me her power of attorney. What do I need to know?
For someone acting as an attorney in fact, You have to remember, the assets of the principal, your mother, are not yours. The principal has given you a power to act on their behalf, for their benefit. If you use the principal's funds and it's not for the principal's benefit, that can be considered theft or fraud and could subject you to criminal prosecution and potential jail time. Keep the principal's funds separate from your own money, and unless you're transacting business on behalf of the principal, keep your hands off it. You are allowed to receive reimbursement for expenses, and you may even receive compensation based upon your duties as an attorney-in-fact, but only if the document provides for compensation and only in strict conformance with what the document provides. Unfortunately, we see bad situations come up where an attorney-in-fact spends the principal's money on themselves and uses up the principal's money in a way that doesn't benefit the principal. In those cases, the prosecutor may file criminal charges such as theft or fraud. We don't want that kind of financial exploitation happening in our community, so be aware that it can be a crime. By making this video and educating people about the rights and responsibilities created in a power of attorney document, we hope to deter that crime from happening in the future.
If I give someone my power of attorney, do they have some responsibility to look out for me?
An attorney-in-fact has a duty to look out for the best interests of the principal. In other words, they have what the law calls a fiduciary duty. They have to act for the benefit of the principal and use due care. Violating that fiduciary duty by self-dealing for their own benefit or by failing to use due care can subject them to civil liability. In other words, they can be sued for damages. An attorney-in-fact is not liable to the principal for making a mistake as long as they act in good faith. But an attorney-in-fact can be liable for performing their duties negligently or in bad faith or for neglecting their duties. An attorney-in-fact who is not able to perform their duties should notify the principal immediately so the principal can appoint a replacement.
How do I show other people that I have the power to act on someone else's behalf?
As the acting attorney-in-fact, you should bring a copy of the power of attorney document with you whenever you are performing your duties for the principal. A copy of the power of attorney document has the same force as the original, as long as you certify that the copy is a true and correct copy.
If I give someone my power of attorney, do they have to keep records?
An attorney-in-fact has a great deal of power that can be abused, but there is also accountability. The attorney-in-fact must keep a record of all transactions performed for 6 years after the transaction. The principal has the right to request an accounting of all transactions performed by the attorney-in-fact. The attorney-in-fact then has 60 days to provide a written accounting after the principal makes a request. The principal should make a request in writing and keep a copy for themselves.
Signing a power of attorney sounds a little risky, but I still need one. How do I protect myself?
Just because you become unable to manage your financial affairs for a period of time doesn't mean you can't take back control or monitor what has been done in your name when you become able. When you are able, you can still protect yourself by reviewing your bank statements and credit card billing statements every month, checking your credit report, investigating signs that your attorney-in-fact may be using your money for purposes that don't benefit you, asking questions, and by contacting a lawyer or the police if you think you have been exploited. If you are aware of an incapacitated adult who you believe is being financially exploited, don't let the fact that a person has a power of attorney document stop you from reporting it to the police. A power of attorney document only authorizes spending money for the benefit of the principal. An attorney-in-fact spending the principal's money on themselves without permission can be theft, and that's a crime that the police should investigate.
If I give someone my power of attorney, does it last forever?
You can terminate a power of attorney document at any time and for any reason. You must notify the attorney-in-fact in writing, signed by you, that you are revoking the power of attorney. You should also notify your bank and any other places where you do business and the recorder's office if the document was recorded.
How do I name someone to make healthcare decisions for me if I'm not able?
You have the right to control your own medical treatment. Normally, you do this by talking to your doctor and other healthcare providers. Your doctor explains the facts about your medical condition and the different treatment options. Then, if you wish, you can talk to other doctors and get their opinions, and you can choose the treatment options that you want. But what if you're too sick to decide? Someone may have to make those decisions for you. The best way to make sure that those future decisions are made the way you want is through an advance directive, a document that allows you to state your choices for healthcare or to name someone you trust to make those choices for you if you become unable to make decisions about your medical treatment. The two most common forms of advance directives are a living will and an appointment of a healthcare representative. Both of these forms are available at the hospital, and someone will help you fill them out if necessary. A living will is a written instruction spelling out any treatments you want or don't want in the event you are unable to speak for yourself and you are terminally ill or permanently unconscious. An appointment of a healthcare representative is a document that appoints someone of your choice to be your authorized agent or attorney in fact for purposes of making a broad range of healthcare decisions if you are unable to do so. You can give your healthcare representative as much or as little authority as you wish to make some or all healthcare decisions, and trust them to weigh the facts at the time a decision needs to be made and to legally speak for you according to any guidelines you provide. The document can include instructions about the kinds of treatments you would want or not want if you became seriously ill, such as whether you would want to get food and water through a feeding tube. Of course, if you're able to speak for yourself, even if you have appointed a healthcare representative, you can still make all your own decisions. You can prepare both a living will and appoint a healthcare representative to deal with the broadest range of future healthcare decisions. Getting legal advice about advance directives can help you clearly express your wishes and ensure that they are enforceable.
These are really hard decisions. What if I don't make them in time?
If you don't have an advance directive, most states authorize someone else, typically family members, to make some or all healthcare decisions. Without an advance directive, decisions may not be made the way you would want or by the person you would want to make them. An advance directive also benefits your family members because it spares them having to guess what you would really want. If there's no close family member available, a court-appointed guardian may be necessary. Appointing a healthcare representative can prevent the need for the court to name a guardian. You always have the right to change or revoke your advance directive while you have the mental capacity to do so. If you want to change the document, it's best to execute a new one. Make sure someone close to you knows you have an advance directive and where the document is located. Give a copy to your physician and ask that it be made part of your permanent medical chart. You may also want to make a small card for your wallet that states that you have an advance directive and provide the name, phone number, and address of your healthcare representative or the person who has a copy of the document.
What resources are out there in the community that can help deal with the legal issues affecting the elderly?
The Office of the Monroe County Prosecuting Attorney Chris Gull staffs the Adult Protective Services Program. Adult Protective Services investigates reports of endangered adults and can take legal action to protect elderly or disabled victims. Investigators may also use medical and psychiatric resources in the community as necessary to protect the health and safety of endangered adults. An endangered adult is someone 18 years or older who, due to mental illness, mental retardation, dementia, habitual drunkenness, excessive use of drugs, or other physical or mental incapacity is incapable of managing his or her property or providing or directing the provision of self-care, and is harmed or threatened with harm as a result of neglect, battery, or exploitation of personal services or property. If you are aware of an endangered adult harmed or threatened with harm, you have a duty to report such information to law enforcement. You can make a confidential report of an endangered adult by calling Adult Protective Services at 349-2665 or the Indiana Adult Protective Services hotline at 1-800-992-6978.
Indiana Legal Services provides free legal help for low-income people and people age 60 or older. Indiana Legal Services also sponsors an elder law clinic to address legal issues affecting the elderly population. If you are low income or age 60 or older and need legal help, you can contact Indiana Legal Services by calling 339-7668 or toll free at 1-800-822-4774.
The Monroe County Bar Association provides referrals for local attorneys who practice in estate planning and who can address other legal issues affecting the elderly population. If you wish to contact the Monroe County Bar Association, you can visit our website at www.monroecountybar.org.
The Office of the Monroe County Prosecuting Attorney has established an Elder Crimes Task Force. The purpose of the task force is to emphasize the importance of crimes against the elderly as a community priority, foster ongoing communication between the prosecutor's office and local law enforcement regarding the investigation and prosecution of such crimes, and promote greater cooperation with community organizations concerned with the needs of the elderly population. The Elder Crimes Task Force promotes public education as a crime prevention strategy. Our hope is that by educating the public on the legal rights and duties that are created through a power of attorney document, we can prevent financial exploitation and criminal victimization and stop them from happening in the first place. Bad situations happen when the attorney, in fact, forgets that it's not their money. Keep that in mind and remember that the money must be spent for the benefit of the principal, and we can avoid a lot of problems. We can all work together to build a safer community. Thank you for your interest in learning the basics about powers of attorney.